Hi everyone, David Miklas, Florida Labor and Employment Attorney here. Today I'm discussing a few questions and answers on national origin discrimination. In 2016, the EEOC issued an enforcement guidance on national origin discrimination that provides the EEOC's interpretation of the law on this topic. How is national origin discrimination defined under Title VII? Generally, national origin discrimination refers to two things. Either one, treating an individual less favorably because he or she is from a certain place or has a certain physical, cultural, or linguistic characteristics of a particular national origin, ethnic group, or two, using an employment policy or practice that disproportionately impacts people on the basis of national origin and is not shown to be job-related and consistent with a business necessity. Now, an individual's place of origin may be a country, such as Mexico, or a former country, or a place that is closely associated with an ethnic group but is not actually a country. A national origin group is a group of people who share a common language, culture, ancestry, and or other social characteristics, such as Hispanics, Latinos, or Arabs. Title VII protects both employees and applicants. Does Title VII protect an individual from discrimination based on a perception of national origin, even if the perception proves to be incorrect? Yes. For example, treating an employee less favorably because of the perception that he is Hispanic or Latino would be national origin discrimination, even if he is not in fact Latino or Hispanic. Does Title VII protect an individual from employment discrimination based on the individual's association with people of a particular national origin? Yes. National origin discrimination includes treating someone less favorably at work because he or she is associated with, for example, marries someone of a particular national origin. So how can Florida employers avoid discriminating based on national origin when recruiting? The EEOC enforcement guidance warns employers to avoid exclusive word-of-mouth recruitment. Word-of-mouth recruitment is a practice of asking current employees to tell their family, friends, or acquaintances about a job opening, and then to refer potential candidates to the employer. Exclusive reliance on word-of-mouth referrals may reinforce the existing racial or ethnic makeup of the workplace and should generally be accompanied by additional recruitment techniques. The EEOC enforcement guidance also warns Florida employers to use diverse recruitment sources. So employers in Florida should attempt to recruit from diverse sources in order to attract a diverse pool of applicants. Recruitment practices aimed at increasing overall diversity will not violate Title VII as long as they do not exclude a particular national origin group. Now, it is lawful to consider language issues in the workplace on certain occasions. Employers may have legitimate business reasons for making language-based employment decisions. It is important, however, to ensure that these decisions do not violate Title VII. An employer may not base an employment decision on an accent unless the ability to communicate in spoken English is required to perform job duties effectively and the individual's accent materially interferes with that job performance. A language fluency requirement is lawful if fluency is required for the effective performance of the position for which it is imposed. A language restrictive policy, such as a policy to speak English only, may violate Title VII if it is applied at all times in the workplace. But such a policy may be lawful in limited circumstances when it's needed to promote safe and efficient job performance or safe and efficient business operations. The EEOC enforcement guidance gives the example that a specific, quote, corporate look or image policy may serve as a proxy for discriminatory customer preference or prejudice, and accordingly would not justify hiring, assignment, or promotion decisions that treat individuals in a disparate manner based on their national origin. Let's use an example that's contained in the EEOC enforcement guidance. We have Alex, a Chinese American college student who applies for work as a salesperson at a clothing store. Alex is qualified for the job because he has worked successfully in retail sales before. Now, the manager who conducts the job interview asks Alex where he was born, states that he looks, quote, foreign, and then notes that he is concerned that Alex's physical appearance would not fit the company's all-American image. Alex is not hired. If there is evidence that the company based this decision on its belief that customers would have a negative perception about Alex's national origin or race, or because the company prefers to hire people who do not look foreign, then the EEOC would have reasonable cause to find, in this case, that the company subjected Alex to unlawful national origin or race discrimination. Florida employers also must be aware of job segregation. Title VII prohibits employers from assigning or refusing to assign individuals to certain positions, facilities, or geographic areas, denying promotions, physically isolating employees, or otherwise segregating workers into jobs based on their national origin. The EEOC enforcement guidance provides the example that a retailer may not require all Filipino employees to work in lower-paying stocking jobs away from public contact because of an actual or assumed customer preference for non-Filipino sales representatives. Now let's go through an example of an unlawful assignment based on national origin. A fine dining establishment opens a restaurant in an upscale urban neighborhood. It runs an advertisement in local newspapers, recruiting people to work in food preparation, serving, and cleaning. Don, a Hispanic man with 3 years of experience as a server at a high-end restaurant, applies for a position as a server with the fine dining establishment. Now, believing that he would be better suited for a position with limited public contact at this location due to his Spanish accent, the hiring manager offers Don a position in cleaning or food preparation. Now, Don is qualified for a server position, as non-Hispanic applicants who are hired as servers, and his accent would not materially interfere with his ability to do the job. Based on these facts, the EEOC will find reasonable cause to determine that the fine dining establishment has unlawfully assigned Don to a position based on his national origin. So, remember, customer or client ethnic prejudices or preferences do not justify discriminatory discipline, demotion, or discharge decisions. Now let's go through an example of an unlawful discharge based on national origin. This example illustrates a hostile work environment based on national origin. Muhammad, who is of Pakistani descent, works for a large automobile dealership. His coworkers regularly call him Camel Jockey, the local terrorist, and the Ayatollah, and they intentionally embarrass him in front of customers by claiming that he is incompetent. The EEOC will find reasonable cause to believe that the constant ridicule made it difficult for Muhammad to do his job and created a hostile work environment in violation of Title VII. I hope this helps. If I went too fast or if an issue is a little complicated, just replay this video. Have a great day.